90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're discussing avoiding conflicts with your clients, and this is especially directed at lawyers, but also clients should know when their attorney or potential attorney may have a conflict. Our guest is attorney Cynthia A. Augello, and she is the chief of the Nassau Lawyer, and she's also has written an article available online about when you're at a conflict or have a potential conflict with your client. Cynthia, welcome back to Law You Should Know.
Thank you for having me again.
Clients aren't usually aware of it, and we're trying to make lawyers more aware of it when they may have a conflict. So just briefly, under what circumstances may a lawyer have a conflict between two clients or with a particular client?
Right. So as you mentioned, most clients are not going to realize that there is a conflict. It's up to the lawyers, the law firms, and everything else to make sure that they're not in a position where they are representing two clients that have adverse interests to each other.
Or may have.
Right. And it can happen. It can happen kind of easily. And as you've been practicing longer and longer, the potential for it to happen is greater. So, there's a couple of examples. You get an attorney representing both sides on a closing, a real estate transaction.
So the buyer and the seller of a house may have different concerns, different issues, so they really need different lawyers representing them so that each one can zealously represent the interests of their client, be they the buyer or the seller.
Right. I mean, think about it. If you're representing the seller and you happen to know, or the seller tells you that there's a defect in the house that they don't have to disclose for whatever reason, and you're representing the purchaser too, how do you tell them without violating the privilege with your other client? And then how are you representing the purchaser properly if you don't tell them? And
also in a divorce, the two spouses may have different issues, may have different concerns, and they each need their own lawyer to represent their independent interests.
Yeah. I've got a case right now that, it's a family suing each other. They all own a property together, and the attorneys on the other side, I happen to represent the plaintiffs in this case, but the attorneys on the other side represent two individuals who are accused of fraud and stealing and everything else, where what if you find out one of them actually did it and the other one didn't do it? How are you representing both of them when they're both being sued? How are you doing that? Because you can't give up one client for the benefit of the other.
That's another situation where there are criminal defendants where they usually need different attorneys representing them because maybe that one is not as guilty. Maybe one of them wants to become state evidence. So they all need independent attorneys who can zealously represent the interests of their client.
Absolutely.
So how should a lawyer, when they have a new client come to them, or perhaps an existing client with a new matter, what should they think about in deciding whether there's any kind of conflict, or on the limited information the client may have? How can the client make sure that attorney doesn't have a conflict?
So, when a new client comes in, it's up to the attorney and the firm to make sure. And again, it's going to be a different process depending on the size of the firm, right? You have an attorney that's a solo practitioner. They're going to know if the person A is adverse to person B, and things like that. And they'll know who they previously represented. They'll know all of that stuff. When you get into larger firms, it becomes more of a process, right? Because even though the lawyer representing the new party might not be aware of a conflict, somebody else in the firm might have represented the adverse party. And as you know, when you start getting involved in computers, all the information is accessible to usually everybody in the firm. So that's a little bit stickier. So, when there should usually be like a conflict committee or something like that, where all new potential matters are circulated around the firm to make sure that nobody has a conflict. They should need to know what the kind of a case is it? Is it a friendly? Is it not friendly? And even if it is a friendly, it might not stay friendly, right? So they need to kind of know what they're talking about to be able to look and make sure that none of the entities are in conflict.
And even in reaching out to an attorney, if you know there's a potential for other suits, maybe you were in an accident, or you're getting divorced, or you want to have a will contest, you do want to make sure the lawyer, even before you give them any information, which may be privileged and may be confidential, before you say anything to them, you want to make sure they're not representing anyone else in the matter.
Right. I'll get calls sometimes and they'll say, I have a problem with this school. And I'll say, okay, hold off. Don't tell me anything else. Just tell me who the school is, or whatever. And if it's somebody that I represent, then I have to cut them off right there and tell them. So you got to make sure, because people don't think that way.
Right. You want to sue XYZ Corporation before you say anything about the grounds for your suit. You want to find out if that attorney or any of their colleagues in their firm have ever represented that company, the potential defendant on the other side.
Right. And that works that way for clients. That works that way with referring attorneys. I'll get calls from attorneys all the time. Want to refer something, they'll tell me the whole thing without telling me who the suit is against or who's involved. And now I've got this information, and that's not necessarily good.
Now, let's say it turns out there is some kind of conflict. Is that the end of the matter, or are there conflicts that are minor, or they're unrelated, or they're 20 years ago, so there can be some kind of workaround,
yep.
Or they're stale?
So it depends, right? The famous lawyer answer, it depends. There are different types of conflicts, right? There's the absolute conflict where it's two adverse parties currently represented. You can't do anything about those, right? Then there's the conflict with a previous client. You can usually get a written waiver on those, right? So if both parties consent to the representation, and that current representation has nothing to do with what you represented somebody. So let's say I represented person A on a will, and then, or person A on a litigation against person B, and then person B says, I need a will done. Okay, that has nothing to do with each other. You can usually get a waiver, because even though they were adverse at each other at one point, you can kind of get it because they're not related in any way. So there's definitely ways around it.
And you mentioned it earlier, but there has to be trust and undivided loyalty of the attorney to the client. So if there's anything that might taint the loyalty or adversely affect that trust, that raises questions which have to be analyzed, before the attorney can proceed.
Yes. I mean, one of the most important things of the attorney-client relationship is trust, right? You have to be able to trust each other, but they have to be able to trust you. They're putting their very important matter, whatever it happens to be, in your hands. And if there's any appearance of a conflict or anything like that, that can mess up the trust between them. It can also land the lawyer in some trouble.
And it's also confidentiality. You want to be able to keep secret whatever the current client tells you, and you want to make sure you don't have any skeletons or conflicts from your past representations.
Right. You don't want to have to be able to, or required to. You don't have to be required to give over information.
And is there a possibility of waivers if there are some conflicts?
There are certain waivable conflicts. Those are usually the conflicts where it is a former client and a present client And the previous representation has nothing to do with the current representation of the new client. So those you could usually get waivers from.
And is there such a thing as a blanket waiver?
There is. Those are usually not recommended because it's impossible to know what you're waiving to be able to waive everything.
And the ethical, perhaps just explain to the public that lawyers are bound by a code of ethics and what protections that offers for the clients.
Right. So, again, because the lawyer-client relationship is built on trust, and it is the duty of the lawyer to make sure that you are representing properly your client. We're entrusted with their care, basically. And you've got certain obligations to make sure that you are representing your client properly, being truthful, and everything else. There are rules of professional conduct that govern the way that clients and lawyers are supposed to treat their clients, and one of those things is raised in conflicts. If there are plenty of lawyers who have gotten in trouble for representing conflicting clients, it can lead to being censured, disbarred, disciplined in some way, heavy fines. Usually if there's a conflict of interest situation and it's found that there was a conflict, the attorney will have to give back all the fees that were spent, plus whatever other sanctions and everything else.
They might even be subject to get sued for malpractice.
Absolutely.
I just want to remind our listeners that we're talking about avoiding conflicts with clients. Our guest is Cynthia A. Augello, and she is the editor-in-chief of the Nassau Lawyer, and she is also involved in defending employers and school districts and colleges and universities. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. If you missed any portion of the program or you want to tell someone else about it, just go to the website at nccradio.org. I think you mentioned before that a client should not waive any future contract conflicts, and a lawyer should never ask the client to waive future conflicts because you don't know what may happen in the future.
Right. You don't know. And, you don't want a situation where if you're waiving future conflicts, if you work with that attorney now, if you don't work with that attorney later, how do you know? I think that's a trust issue, right?
And at the same time, if, let's say, one lawyer represented a husband and wife or a business in buying property, and then there's some dispute, a divorce, or let's say a business dispute, that lawyer may not be able to represent either party because they know inside information, the weaknesses of each party, and so it might be to the disadvantage of one party if they're representing the other party.
Right.
So that lawyer may be conflicted from representing any prior party.
Right, because you have to remember that the privilege between a lawyer and a client belongs to that client. Lawyers aren't able to waive that privilege, and if lawyers have information that they gained from a representation, how can they can't tell their current client without abusing the privilege.
And they might have inside info, they may have a head start, things that they wouldn't want the other party to know.
Right. And you mentioned something earlier about, lawyers can be sued for malpractice. When we fill out our malpractice applications and our renewals and things like that, one of the major questions and a lot of the focus is on the conflict avoidance procedures that your office has in place. They ask, how do you make sure that you don't have conflicts, or how do you make sure, what's your procedure for making sure that you don't have conflicts with your clients? And that's actually a lot of questions. So it's very important.
So there may be times when you want a certain lawyer, you really trust that lawyer, and it may be something that is waivable in retaining that lawyer.
Then it's up to the lawyer to really make sure before a client signs that waiver, Because so many people, you might say, I really want this lawyer. Sure, I'll sign anything. It's up to the lawyer to make sure that that client understands what they're waiving, what the potential consequences of that waiver are, and to make sure that they understand exactly what they're signing.
And that should also reflect the description of the potential conflict, whether it's big or small, and that the conflict, the client, in spite of the potential conflict, maybe it's something from long ago or maybe it's very minor, they can still have that attorney involved.
Right. And if the client says, no, I'm not waiving the conflict, then the lawyer absolutely cannot represent the other party.
And sometimes both sides might have to waive it in, let's say, a business dispute or a divorce dispute. So then maybe it's a bad idea.
Yeah, and they both need to be aware of it in any event.
What other tips do you have to lawyers to maintain ethical relationships, within the firm and with clients?
Again, and again, it's different size law firms. You have different processes, right? So, I would definitely just advise any potential clients who are calling an attorney to, before telling them what's going on, to make sure that they say, I have a dispute with company X. I have a dispute with person Y. Whatever it happens to be, before spilling, the details of everything that's going on. People usually call a lawyer. They're nervous. They've got this whole entire thing in their head. They want to make sure they get every detail down, but it could be causing some sort of potential issues. So I would tell people calling lawyers to do that.
And what about a lawyer you know already and perhaps the possibility of going to a business relationship with them, perhaps buying real property or going on a business venture? What are some of the ethical issues in that situation?
Yep. So that's obviously usually a no-no, right? Lawyers can't usually go into business with their clients. They can't loan money to their clients. They can't do things like that because there's a trust thing, and because lawyers are expected to, watch out for these things, and they're held to a higher standard for whatever reason. they're held to a higher standard, and anything where there might be a potential to deceive somebody or have the appearance of deceiving somebody or using the power that you have, against your client is obviously not allowed.
As we are moving into a more technological world, what other potential conflicts are there for clients or for lawyers?
I mean, there's the technology is a wonderful thing. It's also a very dangerous thing. Just if you think about it, if you're emailing somebody, how often does your email autofill the address that's going in there? You know how many times you start to put an email address and then you'll hit somebody's initials and it goes to the wrong person, and now you're sending potentially privileged information to a completely wrong individual, and then you're like, oops, have to take that back. You can't really put the cat back in the bag. So lawyers have to really be careful. Technology is a great thing. It's also a potentially very dangerous thing.
And as you said, it can work on autopilot. So lawyers and their staffs have to be very careful about that. And also clients, when they're communicating with the lawyer, if it's going to other people, that may waive the privilege and not be protected by the privilege.
Yep. And one thing I like to tell people all the time is don't use your work email to communicate with your lawyer, because your work email is not yours. It belongs to your company that you work for. And if you're sending that, they might be reading your communications and blowing your privilege.
And that brings us to another potential conflict where you're a developer or doing inventions or projects or technology on behalf of an employer, and you may have rights to or residuals or some kind of rights to the product of your work. There may be a conflict between you and what the corporation, as to who should, what your rights are, who owns the invention, who's getting residuals from it. Yep. So you may need your own counsel, and maybe the corporate attorney is not representing your best interests.
Oh, yeah. No, always. Especially when it comes to, any kind of patent type of stuff or intellectual property. You should always get your own lawyers. I will say the same thing for people who are brokers, working in the investment field or whatever. Those people also, when they're negotiating, they'll get an agreement from the corporate attorney to sign. That person doesn't represent you. That person represents the company. And you want to make sure that your rights are protected as well.
I just want to remind our listeners, we're talking about avoiding conflicts of interest between attorneys and their clients. Our guest is attorney Cynthia A. Augello, and she's part of the Augello Law Group, and she's very involved in education law and in defending employers and college investigations, and also in resolving ethical issues. And she's also editor-in-chief of the Nassau Lawyer, the publication of the Nassau County Bar Association. If you missed any portion of the program or you want to tell someone else about it, just go to the website at nccradio.org, and you're listening to Law You Should Know on 90.3 WHPC Radio, the voice of Nassau Community College in Garden City, New York. And what about the role of social media? Clients may put themselves out there, maybe too much information. Lawyers may put too much information out there about themselves or their clients. What are the possibilities on ethical issues on that end?
Right. So, just first, I think I'll hit the lawyers on this one, because you'll get a lot of those, I obtained summary judgment for this client, or I got this result, or something like that. And they'll start talking about the facts of the case. They have to be very careful there that they're not giving up anything, even though the case is over, that they're not giving up any potentially privileged information. They also want to make sure that they get the consent of their clients to be able to post to social media what happened. Some clients don't want the fact that they were involved in a lawsuit splattered all over your page.
And once it's out there, it's hard to draw the curtain on it.
True.
And what about the lawyer putting too much information about themselves on social media?
I mean, everybody should be careful with social media. It can never be erased. It's always found. When I do investigations for one of my clients, whether it's an employment investigation, a school, the first thing I do is Google people and Google stalk and do all of that stuff. And I always say that the FBI should be made up of a bunch of suspicious women, because we find everything out, right? So we could find old Facebook pages. We find the amount of cases that have been resolved when we find things on social media that are contrary to somebody's position is ridiculous. So people really do need to be careful.
And when you're job hunting, when you want to go into a business deal, and once it's out there, you can't put the genie back in the bottle.
You absolutely cannot. And also people should be aware that if you're on, let's say, Facebook or whatever, Twitter, people can tag you in things. So even if you're not putting it on there, somebody else might be putting unflattering pictures or unflattering videos of you on social media that can be used. So it's not just you putting it on there, it's other people too.
And it's good to be careful about what you post in words or photographs, because it may come back to haunt you at some time.
Yes, absolutely. People put things on the internet about a political position or something like that, and then it comes back to haunt them years and years later.
Now, if you're on the other side, you may want, if you see anything unflattering, you may want to print it out, because someone may take it off the web.
Yes, there are ways to go find deleted web pages, though, including Facebook. There's a Wayback Machine. I think it's called something like the Wayback Machine or something like that you can go find old Facebook pages of people.
But it's best to be careful, because you cannot turn the clock back, even if you go way back.
Yep, because people will find it. If it's out there, they'll find it. It doesn't get deleted.
Any final thoughts on avoiding conflicts with clients?
Yeah, it's a good idea. Definitely always be mindful that you as an attorney are the person who is responsible to make sure you're not putting your client in a bad position. As for people who are hiring a lawyer, you want to make sure that you do research the lawyer. Again, go look up online, see what they've done, see what everything else. And when you call them up, just make sure that before you spill everything that you want to say about the person you want to sue or whatever you conflict with, that you let them know who it is so that you're not putting them in a position.
And before you say anything to them, you ask them about any potential conflicts.
Yes.
And just give us your website.
Sure, it is www.augellolaw.com.
And what information about the areas you practice or about conflicts can someone find on the website?
Well, so there is the article in the Nassau Lawyer that talks about conflicts. There's blogs and blog posts on my webpage that talk about that. There's also some information about, the different areas of law and different laws that are all posted on there too.
And if a lawyer has an ethical concern, they can get opinions from retaining private counsel, perhaps like yourself, or asking for a Bar Association Ethics Committee to issue an opinion about it.
They can, or they can also contact one of the members of the Character and Fitness Committee or something like that. And most law firms actually do have an ethics person. One of the lawyers there is signed as an ethics person in their firm.
And as you mentioned earlier, because if they don't, they may be conflicted from representing either party. They may be unnecessarily committing malpractice, and they're going to make enemies out of their prior clients.
Right. And they could be sanctioned and have to give back all the money that they earned doing whatever work it is anyway, plus some.
And on the same token, if you have a loyal client and they come to you with a matter that you're really not versed in, or maybe you're not qualified in the other jurisdiction, is that something you should stay away from?
Absolutely. You never want to dip your toe into something that you don't know what you're doing because you're not serving the client, and that's what our job is to do. So if you have an instance where it's something that you're not 100% familiar with, make a referral. But when you call that referring attorney, make sure you check conflicts with them first.
And maybe you can work with them on the matter. But the client, just like with medical specialties, the client is entitled to an experienced lawyer in that area of the law.
Absolutely.
Okay, I'd like to thank Cynthia A. Augello for being our guest on Law You Should Know. If you missed any portion of the program or you want to tell someone else about it, just go to the Law You Should Know podcast website at nccradio.org. And please join us next week at this same time on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York, for another program on Law You Should Know.